to function in their day-to-day life.
Can I ask about the tradition with respect to addiction?
Yes.
Because I think you and the government agree. I want to find places of agreement here.
Yeah.
I think you and the government agree that there is a tradition of prohibiting gun ownership, possession by those who are addicted to drugs, correct?
Yes, we agree that the historical, we agree that the historical tradition of habitual drunkards can support laws with respect to addiction, which is, I'm happy to talk about the state laws, is really the dominant approach that states take.
As my questions indicated, I think you have a strong point there on that being the dominant approach when it started up. Now then on this statute, so taking what you just said and applying it to this statute does cross-reference the Controlled Substance Act, which then does define addict as a habitual user so as to endanger the public morals. Just leave it at that. And my question is that definition of addict good enough, in your view, to satisfy the tradition of prohibiting gun ownership, possession by addicts? And if not, what is the delta?
Yeah, I think that definition pretty well maps onto the historical tradition. It's a little bit of an unusual definition because it has these two prongs. It refers to a habitual user as someone whose habitual use either is essentially because they're addicted or just is endangering public safety. But I actually think, while that may be a bit of an odd way to think.
It says endangering the public morals.
It does
which
say,
means
I think look, if we were here in an addicted to case,
right,
there's some discussion to have about whether some of that language is a little bit broad and a little bit problematic from maybe just a little, but I think what the definition is getting at is if your use is so excessive, either because you're addicted or if it's a product of choice. Either way, if your addiction is rendering you a threat to yourself and other, your habitual use is rendering you a threat to yourself. I think that maps on to historical tradition.
So you're good, let me just summarize, you're good with addiction being a tradition and with this definition of addiction being good enough.
The only minor
correct?
caveat I will give you is the government has in fact accused my client of being a drug addict, so I don't want to foreclose literally any argument that might be made about the addicted to prong, but as a conceptual matter,
a legal matter,
we don't have a problem with the historical tradition supporting the use, supporting laws that prohibit drug addicts from possessing firearms.
The government didn't accept that. They said that definition doesn't control.
I think what
they said it had to be more focused.
I think if I understood the government, I think they're focused on the fact that the definition specifically refers to narcotic drugs, which is a narrower category than controlled substances. We aren't suggesting that the definition has to be read literally in hoc verba into the 922G3. I think you could say that the standard that the definition of addict is setting out for addiction can apply as a controlled substance. And this is actually the way, when the government does prosecute under addicted to, several courts use this as the jury instruction to give content to what the concept is.
So do you think